Okay, now we'll talk to Marvin, and we're going to talk about the establishment of the Federal Milk Marketing Order 51. Let me clean up my screen a little bit here for a second. Before I go forward, just want to thank Marvin for agreeing to do this. Marvin and I have been friends for many, many years. I came into the Department of Ag many years ago, knew nothing about milk pricing, and gradually picked it all up just from hanging around with Marvin a lot. So I have to thank him for that. He's been a great resource to me personally and a good friend, and I'm really happy to have him here. People don't understand the significance, I think, of Marvin and his stature in the dairy world. When the co-ops, DFA, Land and Lakes, and the California group of co-ops needed an attorney to represent them on perhaps one of the most important endeavors that they were ever going to do or pursue collectively. Marvin's the man that they hired as their lead counsel, and he delivered the goods as we now have a Federal Order 51. And here it is in the map, the lime green over here on the far left. It's only been in the map for 2 years now, established in 2018 after many years of litigation and many plane flights and many hotel rooms by Marvin. Thanks, Marvin. Appreciate you coming on. We're gonna stop sharing my screen now and just try to have sort of a conversation, and hopefully we're good that way. If anybody needs to give me direction with regard to how to, so I'm gonna go to, there we go. If people go to speaker view, I think you'll be able to see the best screen for this portion. And I'm gonna move my screen, hold on a second. All right, now, Marvin, let's talk about, tell us, first of all, why don't you give people a little bit of background? Because again, I gave a little tiny bit, but why don't you just give us a little bit of background about how you got into representing particularly dairy cooperatives, and particularly with regard to these, the federal and state pricing regulatory agencies.
Okay, well, thank you, Brooke, and good afternoon, everyone who's online here for this webinar. And I'll go, real quick. I'm a York County dairy farm boy who went to college and law school and decided he wanted to try to use terrific interest in dairy, growing up, 4-H and all those good things. And went to law school in DC at Georgetown, and got a job. Worked my way through law school at USDA in the dairy division of market order work. Was fortunate enough to get a part-time job there, and got to know some of those regulations, and threw the resume around a little bit. Got a job with a law firm in DC that was involved in what was then called the Midwest Milk Monopolization litigation, and I kind of came on as the the milk guy right out of law school, because those antitrust lawyers didn't know a lot about the dairy regulations, which I got involved in then, and did that for 4 years. Came back to Pennsylvania, opened up my own law office practice, and made contacts within the industry, and over a period of time came to do work in federal milk marketing orders, and more recently, in more recent years, more time with the Pennsylvania Milk Marketing Board regulations. So
I just always think, Marvin, you have one of the most interesting career paths of anybody I know. And, to build a practice as unique and nationally known, it's just quite a, something to be honored, I have to say. It's not, younger attorneys these days don't quite, maybe they just don't have the opportunities to do what you did, I guess.
Well, I was very, very fortunate to, carve out a little niche, which has been good for me.
Yeah. Okay. So tell me about, what about the California situation and sort of the pre-existing California before 51 led to this beginning?
Right. Okay. So just to give a little quick historical context so everybody can kind of think of it this way. You saw the map, Brooke had the slide up of the federal order areas, and it looks like a crazy quilt in a way across the U.S. They're not contiguous to states or anything. Well, for the last 80, milk regulation in the U.S. has been in place for 80 years, federal and state, because all the laws that set up the authorization for these regulations were passed in the Depression, including the federal law, and many state laws at the same time, including California and Pennsylvania. So the federal law was unique in that it was not a top-down, everybody must participate and regulate, such as, like you think of the EPA perhaps, or other federal regulatory systems. The Agricultural Marketing Agreement Act was an act from the federal government that said, we will regulate if you want us to, essentially. You must request regulation. So it's never been a coast-to-coast, cover all the U.S. Type of regulation, but it's been a pattern of marketing orders that have evolved over those 80 years where they have been requested. And initially in the 50s, there were over 120 orders in metropolitan areas around the U.S. And in more recent years, those orders have evolved with marketing patterns of the participants in the marketplace to cover larger geographic areas with changes in technology and movements of milk over larger geographic areas. So we've got 10, 11 orders now in the U.S., including California. California had its own system for years. It didn't invite the federal government in. It had a system which was very beneficial to and satisfactory to producers and processors, handlers in the dairy industry. And it was very favorable and in a couple of different ways. On the producer side, in the mid 60s, there was a quota program that was initiated in California, which allowed all producers in California, or enabled producers in California, to share in the California Class 1 marketplace with a market-wide pool, and the quota was issued to everybody. And if you wanted more, you could buy more. It was transferable through but quota was basically a share in the Class 1, or the blend price, as you think of it in the federal order system. At the same time, California was very favorable for processors because they set prices which, for manufactured products, cheese, butter, powder, etc., which were somewhat less than the rest of the country. So it was a nice place for processors to invest in brick and mortar. It was a great place for producers to produce milk. California, for many years, had the lowest cost farm production, cost of milk production in the country, and farmers could go to California, or farmers who were in California could produce as much milk as they want, and the plants were going to be there because it was profitable to be a manufacturing plant in California. And you had a growing population which had an expanding demand for fluid milk, so you had quota that was issued and additionally reissued. So that went on, and it was very good for many years. That is, there was no demand in California for other regulation other than the state regulation that was satisfactory to everybody. This changed in the latter part, in the early part of 2000s. In particular, it changed from the producer perspective when in 2007, the California Department of Food and Agriculture changed the way they priced milk going into cheese. Cheese at this time was becoming a very large, a substantial portion of milk usage in California, up to 40% or pushing 40% of the production in California going into cheese. The price was, the formula for the price of milk going into cheese was changed so that it was lower and lower and lower than the federal order price, which was applicable in the rest of the country. So in 2000, from 2000 to 2007, it was 40 cents or so less than the federal price in the rest of the country, and then it veered sharply south, so that from 2008 to 2014, it was $1.43 less than
Marvin, we're getting some feedback from you.
Yeah. I don't know if it's, just see if it, say something now. Let's give it.
Okay, 2008 to 2014.
Try to move your computer a little bit. Maybe it's just something. Is it, I forget, is it a laptop there or a desktop?
Let me talk slow. Are you getting it now?
Yeah, I think we're still getting it. I wonder what that is.
I'm sorry.
There you go. There you go. It cleared up.
Okay,
All
so
right.
the price of milk going into cheese in California was reduced sharply by actions of the California Department of Food and Agriculture, the regulatory agency, so that from 2008 to 2014, it was average $1.43 less than the federal price, the price in the rest of the country. And from 2012 to 2015, it was almost $2 on average, $1.96 less than the price in the rest of the country.
Is there a reason? Go ahead. Tell us why that is.
Well, the formula was changed by order of the California Department of Food and Agriculture, which has price formulas similar to which set minimum prices for milk for various uses in California, similar to, what is in the federal milk order pools. But the formulas were different, and essentially the value of whey was devalued.
Okay.
Was reduced so that there was a very lesser value to whey, which is part of the value for milk going into cheese, and it resulted in the pay price to farms being reduced substantially, so that producers in California, while they had always had a price that was competitive over the years with the rest of the country, not a price higher than the rest of the country, but one that was close, and a market that was very good, strong, always demand for their milk. This changed, and their price went down sharply with the changes in the formula for whey. The producers in California asked for hearings. There's a hearing process in California, just like in federal orders or with the Pennsylvania Milk Marketing Board. They asked for hearings. They requested changes in the price of whey. It was tweaked and tinkered with minimally during those years. There were repeated multiple hearings. And to make a long story short, there was no satisfaction. They could not get any satisfaction on the producer side for the pricing in California, mostly the price of cheese, Class 4B milk, price of milk going into cheese. It got to the point where they just were not willing to live with regulation under the California Department of Food and Agriculture anymore, and the three cooperatives representing 75% or so of the producers and production in Pennsylvania or in California, Land O'Lakes, Dairy Farmers of America, and California Dairies Incorporated, said, we're going to now request, as I mentioned before, federal regulation is subject to request. We're going to request USDA to put a federal order in California. And basically the theme was, we want to bring California, it's time for California to not just be out here in a system of its own, an island of its own. It wants to be part of the rest of the country so that their price is the same as the rest of the country, and they're competing in the same marketplace as the rest of the country, which in fact, the processors were competing in a national market in manufactured milk products, which is why the federal system had a uniform, and did have at that time, and still does, a uniform Class 3 and Class 4 price throughout the whole country. So we filed a petition with USDA February 3, 2015. The initial letter went in. We had a 40-day hearing in the fall of 2015, 40 days of hearings. It was briefed, and as you mentioned, Brooke, eventually an order was implemented and finally up and running 2 years ago, November.
Okay. Now, you talked about this quota system, which I know when you and I have talked about this before, I kind of used a very crude analogy, which is this was created in California in order to share the benefits of the class one market, that has the premium and, is obviously generally regarded as, the highest priced, that's going to give you the highest return. So that quota system, I said, well, that's kind of like our order premium in the sense that it is, capitalizing upon that better price at class one to get something back to dairy producers, but yet they had, I assume, millions of dollars invested in the purchase of all this quota. So in replacing the state system with the federal system, that quota had to be accommodated, right?
Yeah. So I should have could have mentioned that, in order to have a hearing, it was a prerequisite for California producers to request a federal order was for it to be possible for the federal order to recognize in some way the value of quota in California. The capitalized value of quota, the value of quota in California was like $1.2 billion.
Okay, so
roughly at this period of time. That was the hearing testimony because it was being bought and sold around $500 per pound of solids not fat quota, and the whatever number of pounds of quota that were in place was issued. Okay. So yeah, I mean, quota was just one of a mechanism in California for sharing the class in that system for sharing the class one values. In order for the federal orders, which don't have quota anywhere else, and do not have a legal authorization for a quota system, in order for a hearing to have an order in California, there was a provision in federal legislation in the Farm Bill in 1996 and again in 2015 that authorized the Secretary of Agriculture, U.S. Secretary of Agriculture, to basically accommodate quota in a California order if there was to be one. So that allowed the request to go forward, and it was heard, and the order came in. And
all right. So the quota concept carried along with it. So California has a slightly different way of paying out a class one price, I guess, is probably the way to say it. Yeah.
I mean, the California, I call it a wraparound provision. I mean, the California quota system stands in place. It's fine. I mean, monthly there is something in the area of 35 cents per hundredweight of all producer milk in California goes into a kitty, and from which quota persons who own quota are distributed a quota value premium, so that you've got a freestanding quota program and you got the federal order wrapped around it. The rest of the value of the federal order pool is distributed in essentially the same manner as the pool in Federal Order 1 or Order 33 here in Pennsylvania, component values, et cetera.
Okay. And then in terms of opposition then, what, probably good to just reiterate for those who might not be as, when you talked about it was, an invitation to the feds to come in and regulate us. That's an invitation from the producers.
Correct.
Now, from the processor's standpoint, what was the pushback and what were the arguments? And, go ahead.
So the opposition, there was opposition. There was very sustained opposition, very strong opposition from the processors and the cheese manufacturers in particular, because they had, basically close to a $2 per hundredweight advantage in buying milk to make cheese under the California system versus the rest of the country. And, they were interested in maintaining their advantage, and they contested the request for a federal order very vigorously, said that, their costs of production were higher and California, et cetera, and that they wouldn't be able to compete in the rest of the country. And they, there were those arguments to attempt to maintain their economic position. USDA declined to adopt any special lower price in the California federal order. California federal order prices are the same as for class 3 and class 4, same as for the rest of the country. The the accommodation, so to speak, for the manufacturing industry in California was that similar to the rest of the orders in the rest of the country, really like the orders in the rest of the country. Manufacturing milk does not have to be pooled. So there's the depooling option, which allows in situations where, depending on the price variations, if it's not advantageous to pool class 3 milk, such as at present times when the class 3 price is higher than much higher than class 4 and 2 and even higher than class 1, it's not advantageous to pool it, so it can be depooled. The producers, the cooperatives that I represent, the producers requested USDA to not allow depooling in California, to have what we called an inclusive pooling provisions, and that was declined by USDA.
Okay.
So USDA went with, they accommodated the quota, California quota system, which those accommodations were not supported, were opposed by many interests in California. Also, those interests that do not have quota, or a lot of quota, but USDA accommodated quota, basically used the template of federal order pricing and pooling that exists in the rest of the country, and promulgated an order for California, which represents, should have mentioned earlier, 20% of the production, roughly, a little less than that right now, production in the country. Okay. So it's a major change in making the national regulatory system for producers much more uniform from coast to coast.
And I assume that the argument about processors not being able to compete without this larger, margin, so to speak, for cheese. I mean, the other processors all over the country are competing without that artificially large margin, correct?
Well, yeah, I mean, in fact, the testimony in the record, I mean, the evidence we had in the record showed that, in the highest concentration of cheese manufacturing in the country, which is in the upper Midwest and Wisconsin and Minnesota, I mean, they pay the established federal minimum price plus premiums, substantial premiums. So besides the fact that California was $2 under the federal price, they were paying, more than $2 less than the manufacturers, the processors in Wisconsin, several of whom also owned manufacturing plants in California, and they were paying, $3 more in Wisconsin than they were in California. So
now, is there anything unique about California's ability to use that model that has been in place all over, based on the geographic expanse of California? You're talking about a pretty unbelievable distance between San Francisco and Los Angeles. We're not used to those kind of distances in one state. Is there accommodation for that?
Well, I would say that California's geographic configuration, having the Pacific Ocean on its entire, western coast, and having relatively low populated areas on all of its other borders, its relative geographic isolation allowed its state pool system to exist probably separate from the rest of the federal system for longer than it might have otherwise. Because the state cannot regulate interstate commerce. The federal system does regulate interstate commerce, which, I mean, that's a sub-theme of the California hearing. The pool captures some substantial values of interstate class 1 transactions that were not able to be captured in the California pool.
Yeah, okay. Now, let's go to the present day, and we don't have, let me know, Ross, if there are questions piled up. I didn't see any. Let's go to the present day in terms of, we've had a lot of market volatility, obviously, since 2018, whenever the 51 came into being. Is there a way to judge what impact it's had upon either the surrounding regions or, even regions as far away as the Northeast, Region 1, or Order 1. Are there observable impacts that can be determined at this point, or is this a longer term project to figure that out?
It's certainly a longer term project to have any meaningful observations. I spoke with, the folks out in California from all of the co-ops that I worked with, and some other folks in California, about how it's going for 2 years. And, the events of 2020, the market turmoil, volatility that you related earlier, of kind of, they're everywhere, and they kind of dominate all, analysis of everything. But I think that while there were folks from the Northeast, some folks from the Northeast and from the Southeast who were concerned and testified out in the California hearing, they were concerned that, you raise the price in California, California is going to generate a lot more milk production, and that's going to basically have a negative impact in the rest of the country. That hasn't happened. I mean, California's share of the of national milk production is actually a little less now than it was, back at the hearing time, because, there are really other areas of the country that have expanded their production much more.
I see.
Michigan, South Dakota, West Texas, Kansas,
Idaho, is that in there?
Idaho's, is flatter than some of those other areas.
Okay.
But it's still very substantial.
All right, so that's one factor that, apart from market disruptions from other things, just the mere, the observable fact is that many of these other states have actually picked up and increased, production, as opposed to California doing that.
Right.
Is that right? Okay.
Right. Yes. Yeah. But California the order's been a substantial plus to California, and because it has brought the prices for their manufactured products up, and made California producers, essentially brought them into the national system, which is what they really wanted, and made them a part of the national system, and made them put them on the proverbial level playing field with the rest of the country. And it's it has they're not ready to go back. They're ready to stay where they are.
Right. All right. So it sounds like a long-term thing to figure out if any, I hate to use the word unintended consequences because we hear that so often in front of the PMMB, but whether there have been any. All right. Well, it is one, and we don't like to hold people unless they want to voluntarily stay. So if we have a drop off with attendees here, we understand completely. Ross, do we have any questions there? I got to look now and see. It didn't look like we did.
No, there are no questions in the queue. So I want to thank everyone for participating. And again, we will have our next quarterly update in January. So we encourage you all to participate then as well.
All right, great. Well, thanks everybody. I really appreciate it. And email us at the Ag Law Center if you have ideas for topics or guests to be on these webinars. And Marvin, I really want to thank you. I'd love to talk to you someday about depooling as an entire subject into itself, but we'll have to leave that for another time. Yeah. So thanks so much. And thanks everybody who attended. We'll see you all in January.